Sixth affirmative defense, punitive damages prohibition. Defendant's sixth affirmative defense regarding punitive damages should be stricken as it fails to meet the pleading requirements of Federal Rules Civil Procedure 8b and the fair notice standard established in Woodfield. Like defendants' other affirmative defenses, this defense provides no factual basis whatsoever, leaving plaintiff to guess what specific legal theory or factual circumstances allegedly bar punitive damages. The defense states merely a legal conclusion without any supporting factual matter. Under Woodfield, affirmative defenses must be pleaded with sufficient specificity to give plaintiffs fair notice and prevent unfair surprise. This defense particularly exemplifies the unfair surprise created by defendants' bare legal conclusions because it forces contradictory positions regarding municipal and individual liability. The defense creates irreconcilable contradictions for defendants. If Stewart acted independently without municipal authority, this would establish potential municipal supervisory liability under Municipal for failure to supervise. Conversely, if Stewart acted with municipal authority as final policymaker, his actions would create direct municipal liability while potentially barring substantial individual punitive damages. Defendants cannot claim immunity from both individual and municipal liability without providing factual support for their theory. The defense should be stricken because it fails to meet basic Rule 8 requirements by providing no factual articulation of the claimed basis for punitive damages immunity, creating an unfair surprise, and preventing meaningful responsive pleading or targeted discovery. 18th affirmative defense, special damages. This defense provides no substantive content and fails to specify any legal theory for challenging damages. It violates the fair notice pleading requirements of Woodfield. Defendant's 18th affirmative defense asserts that plaintiff failed to plead special damages with the required specificity. This defense is legally insufficient for three reasons. First, plaintiff has not pled any special damages in this action. Special damages are those that are not the necessary or inevitable result of the defendant's conduct. It must be specifically stated under Federal Rule Civil Procedure 9G. Plaintiff's complaint seeks compensatory and punitive damages that naturally flow from the alleged constitutional violations, not special damages requiring heightened pleading. Second, in Section 1983 cases, compensatory damages for constitutional violations, including damages for pain and suffering, emotional distress, and other intangible injuries, are considered general damages, not special damages. Conclusion: wherefore, plaintiff respectfully requests that this court grant plaintiff's motion to strike affirmative defenses as follows. Strike the following affirmative defenses without prejudice. Defendant's first affirmative defense, failure to state a claim, without prejudice to defendant's right to raise the issue through proper procedural vehicles under Rule 12. Defendant's second affirmative defense, statute of limitations. Defendant's third affirmative defense, standing. Defendant's fifth affirmative defense, no municipal liability. Defendant's sixth affirmative defense, punitive damages prohibition. Defendant's 18th affirmative defense, special damages. And defendant's 19th affirmative defense, damage caps. Strike the following affirmative defenses with prejudice. Defendant's 7th affirmative defense, Mississippi Tort Claims Act. Defendant's 8th affirmative defense, estoppel and res judicata. Defendant's 9th affirmative defense, good faith, honest belief. 10th affirmative defense, comparative fault. 11th affirmative defense, failure to exhaust administrative remedies. 12th affirmative defense, failure to mitigate. 13th, adequate state remedy. 14th, reservation of 8C defenses. 15th, unclaimed hand. 16th, after acquired evidence. And 17th, Heck v. Humphrey. And 20th, attorney's fees. Strike defendant's fourth affirmative defense, qualified immunity, sovereign immunity, legislative immunity, and or absolute immunity as to the city of Guntown only and without prejudice as to defendant Stewart, and grant any such other relief as the court deems proper and just.